We have a quorum, Mr. Cardenas, Mr. Rosendahl, Mr. Koretz, myself, Bernard Parks is the chair. What we'd like to do, let's see, do we know from the clerk, is Mr. Englander coming? Okay, so we'll have a full body. What we'd like to do is ask the committee whether we can handle 7 and 9 on consent, and then we go to our 6 items in closed session, and then come back for our last 3 items on the regular agenda, and so that we can have some order on it. Item 8 on the financial status report we'll hold for last, so that we can address all of them.
I'll support 7 and 9 on consent.
On consent. Anyone have any concerns about 7 and 9 on consent?
And just for actually clarification purposes, in the report it talks about the E3 Expo from June 6th through 9th, 2010. That actually should be 2011.
Now, which...
That's on item 9.
On item 9, they made a mistake of, instead of June 7th through 9th, 2010, it should read 2011.
That's correct, yes.
Okay, so as amended?
It's
I'll make that
amended.
amendment.
Okay. All right. Well, evidently, the CLA notes are accurate then, because it shows the 2011.
I see 11.
Okay. All right. But also on, if we could ask just one quick question on item 9, do we know if this is accruing interest against the city as far as this item?
That's the Nintendo item, right?
Yeah.
Yes.
If it is, what I'd like to do is see if we can't get it moved.
That's the convention center.
Yes. Just as, with this, paying back this, what is it, $96,000, is it accruing interest until we pay them?
Yes, the monies are all in the city accounts. So
Okay, what is the amount of interest?
we have not computed it to this day.
Okay.
It's a refund.
Point of clarification, Mr. Chairman. So basically what you're saying is, what interest they get is interest accrued. It's not at a separate rate apart from what the money is accruing in that account.
No, and actually, when we refund the basic, the money. We have not refunded the interest to go with
Okay.
it.
So as far as you can tell, the amount that we're approving today does not include interest,
No.
and they're not coming after us for interest.
No, they're not.
Okay. Now, let me ask that we can see if we can get this on the council agenda this week. Is that possible?
The soonest would be Friday.
Yeah, that's fine. Okay. So we'll move 7 and 9, and with the request that number 9 be on the council agenda this week. We'll now adjourn into closed session for items 1 through 6,
Thank you.
and then come back for items 8, 10, and 11.
We're going to the back.
That you might do.
See you all in a couple hours.
Item 10. It's okay.
Anything on the closed sessions that we have to deal with in open sessions? Okay.
Nope.
So we have 3 items left. We're going to save the FSR, which is number 8, for last, so that we could then go to item 10 or 11, whatever.
Yep, so we'll start with item 10. Item 10 was continued from the prior week, and this is a CLA report, city attorney reports, and revised ordinance relative to establishing a citywide administrative citation enforcement program under the management of the Office of City Attorney and creation of special
Before
fund.
staff comes up, let me get the public comment cards.
Yep.
And then that way you can digest what they're saying.
And there was a revised ordinance that was circulated today.
Okay, we could start on the 4 side. Mr. Wolfberg, Maury Goldman, Garion, is it Bojink, and Lee Pasternak. We have 4 come up at this time. Let me just say, I think many of you were here last meeting in the sense of an hour or for the time, so we're going to give each member 1 minute on this session. Okay.
Mr. Chairman and committee, George Wolfberg, I'm representing the Pacific Palisades Community Council, which is overwhelmingly voted to support the concept of the ACE program. I'd like to thank council members Koretz and Parks for getting us to this day. This proposed pilot, I think, is not exactly what we were thinking of, but I think it's a good start, and we'll see how it works, and recommend you approve it.
Thank you. Maury?
Maury Goldman, Urban Solutions, representing Clear Channel Outdoor. We have some concerns with regard to the revised draft ordinance that was released today. We understand that it is a pilot project or pilot ordinance, and that building and safety is not part of the pilot. However, in the body of the draft ordinance is a schedule of fines relating to signage. And we wanted to request that this schedule be referred to Plum. At the same time as this is going on, there's a draft ordinance being developed through the Planning Department and Building and Safety, which has very specific enforcement provisions. And we think it's important that those enforcement provisions be consistent. And that would be our request. Okay. And it is going to be, just for the committee's information, Plum is going to be hearing the draft ordinance on October 18th. So this is something that is moving forward. Thank you.
Thank you.
Good afternoon, City Council. My name is Lee Pasternak, and I'm a property owner in Los Angeles for over 30 years, and I want to take this opportunity to thank you for allowing me to speak. I'm against the current ordinance the way it is currently drafted. The City Attorney's Office and the manipulation of the judicial system is currently relying on a criminal misuse of the Backrack case, which has strict liability in it. This case allows the City Attorney's Office to illegally extract money from unsuspecting tax-paying property owners with unreasonable code violations and not allowing them the necessary time to cure. This type of extortion by the City Attorney's Office on property owners is an attempt to pay for the city's committing ongoing waste through improper using of the city's resources and the continuing to place financial burden on the public.
Okay, thank you.
You can turn that in for the record if you'd like, the written document, if you'd like.
Okay, thank you.
Give your name.
Thank you. Darian Beaujeau. I really
Before you
need
get started,
to...
let me just ask the last speaker for is Haldis Topple. Come up.
Oh.
Okay, you can get started. Ma'am.
Okay. You're started on it. Okay. Darian Beaujeau. I'll take the minute, but I need 2 hours. The thing is that I'm all in favor of an ACE. It's a great idea, but we really have to get it right. And this really is not right yet. It's good to raise revenue, but we've got to be fair about it. Now, the thing is that I've got something to pass out to most of you. I only had 5 copies, and only the first one has a declaration from the Apartment Association about the abuses under present law. But we have extreme power abuse right now, and we need to require that minor property code violations be handled through an ACE program, but a fair one. I've tried to outline it in my papers. I've given you declarations. I've got a lot more to say, and I don't know where to start, but only in Los Angeles do we have a case that holds contrary to the California Safety Code, which allows people notice and a fair opportunity to cure violations before criminal prosecutions. And thank you so much.
And this is your document that you referenced?
That's one of them. Actually, the main document is this summary of what I've tried to say that I didn't have time to say.
Mm-hmm. Did you give us a copy of it?
Yeah.
Okay, here.
Yeah, that's it.
Okay.
That's very important. I gave 2 declarations. One was a housing task declaration about violations in the past.
Okay.
One was an Apartment Association declaration, and I think there was something else.
All right, thank you very much. Ms. Topple?
My name is Haldis Topple. I'm the Vice President of the Marcus Knowles Property Owners Association, representing 1,250 homes in Marcus Knowles, a community of Pacific Palisades. Our community has suffered from brazen disregard of laws, ordinances, codes, and rules. And those in the field with enforcement have been embarrassed by the lack of ultimate enforcement by the city attorney's office. At the same time, the city departments affected with, charged with oversight, have been frustrated by not having the support they need in the field. The residents of Marcus Knowles applaud Councilmember Paul Koretz and the city attorney, Carmen Trutanich, for their work with this ordinance that will give back the dignity to those city inspectors, restoring the city's restoring the confidence of the residents of this city, and ultimately stop the brazen approach of the scofflaws. Thank you very much.
Thank you very much. Let me go to the next cards are against. Michael Millman, Scott Crawford.
Scott left.
Okay. Harold Greenberg. So Scott is not here. He's for the record. He's card. Also, Noel Weiss and David Cheney. Okay. Mr. Greenberg.
Good afternoon. Thank you for allowing me to make just a brief comment. I think everyone knows that there are already far too many regulations and penalties, even if we look at REAP, LAHD. Mar Vista in Venice is impregnated with at least hundreds and thousands of illegally built garages built right on property lines. You're going to be seeing thousands and thousands of inappropriate penalties. No due process. Looks like a star chamber program. The apartment owners were never consulted by the city attorney or anyone. Why don't we sit down over a cup of coffee and take a look at this piece of legislation so it would be fair and equitable to our members? Never. So I think we got to go back to the drawing board, and let's all that have a stake in it, and let's do it right this time so we're not hurting people in Venice and Mar Vista who have bootleg units who need it for their income. Thank you.
Harold Greenberg, AGLA strongly opposes this legislation. It's ill-conceived. Frankly, it is debt collection by criminal prosecution. When you read this particular proposed ordinance, if you don't pay the fine, they will criminally prosecute you. That was outlawed by our American Revolution. In addition to that, they changed the burden of proof. Once they file on you under this proposal, it is a prima facie case. The burden then shifts to the owner. That is not our democratic system. In addition to that, this is supposed to be an alternative proposal. It is not. If you read it and read it carefully, it says it is in addition to criminal prosecution, general manager's hearing. So what are we saving? All it is revenue grabbing and putting power in the hands of the city attorney's office. When are we going to look out for the people who provide housing in California, the landlords?
Thank you, Mr. Greenberg. Mr. Cheney? I'm sorry, Noel. I'm sorry.
Oh, thank you. Number one, I don't think it's right that we should get this ordinance on the same day. That's not right. And honestly, it should be continued just for that, because this is the most poorly drafted thing I have almost ever read. This is an embarrassment to the city attorney's office that they even put this together. It is legal malpractice. It is political malpractice as far as I'm concerned. Secondly, again, a great idea poorly executed is worth zero. I don't know how in good conscience any of you could vote for this under these circumstances. If Bill Carter's talking about decriminalization, you know what? Pick what you want to enforce and just make it an infraction. And then the police issue a ticket, and then you deal with it as basically a traffic ticket. There should be some diversion. There should be some mediation. The idea of having the city attorney be judge, jury, and executioner is outrageous. It concentrates power in this man's hands, but in any city attorney's hands. That's never a good idea. You want to, at a minimum, maybe put it in the controller's hands. Where are the metrics on this? Where's the workup? What's it going to cost? These administrative judges aren't going to serve for free. The police department isn't going to serve for free. It's just not right. It needs further work. Thank you.
Before Mr. Cheney, hold on just a minute. Could we have those seats? Mr. Huey, Lewis, is it Wonderman? and Jetta Romero. Okay?
Okay. I'm David Cheney. I've spoken before you before. I'm like the face of the bankrupt apartment owner here in Los Angeles. I want you guys to understand that there's something very similar to this provision already, which is the fire department. I have properties over in Echo Park and Silver Lake. They fly over with a helicopter. They write you citations from a helicopter picture, and then they send you a $300 notice without giving you any chance to fix the problem. I just got red tagged on a property. I had no notice of noncompliance, but the basis of it was a helicopter photo based in July. Now, you guys, this is what's going to happen, but on a much larger scale. Everything you guys do is done to make money. That is not right. I'm just now having to get some palm trees skinned over there. $900, that was not included in the first note. And now, those tenants don't even pay me that. 2 units don't even pay me $900. This is how it goes, you guys, and then there's no way to appeal. The guy goes, I'll see if I can get it removed. I said, get it removed? It shouldn't even be there. I was never cited. Jesus.
Ms. Romero?
I'm Jutta Romero. Good afternoon. I'm a landlord, and I think that we already have enough ordinances here in this city where we have to pay whenever you need money. All the landlords are rich, but we are not, because all the code enforcement and that stuff. On this new ordinance, there is also something that you want people to snitch on one another. I lived in East Germany. You know, that's what the communists did. You don't do that here. That is awful. So you can cut back on some other stuff. I'm sure that the city is wasting lots of money, and you don't need to always go to the landlord and ask them to bring more.
Thank you very much. Mr. Hughes, can we have that seat and ask Mr. John Villanos to come up at this time?
Good evening, council members. My name is Bill Huey. I'm the president of Fair Housing Coalition. Right now in the city of...
What is your name?
Bill Huey, H-O-O-E-Y. Right now in the city of L.A., landlords are treated like criminals. Everything at the housing department, when they come out to a building, every infraction, every code violation, the landlord gets cited. I've been in apartments with landlords where tenants admit having gotten drunk, kicking in the walls, and the inspector says, oh, it's not your fault. And they cite the landlord. They won't even give a citation or write up anything about destructive tenants. And if a tenant gets a landlord cited once or twice in 2 years, the landlord should have the option to evict him just on that, just on getting cited. There are 1,700 landlords in REAP in L.A., and a lot of them are because destructive tenants have done things that put the building in REAP, and yet the landlord came and evict destructive tenants. Any kind of violation system created or any new law should go after the guilty party. I'm not in favor of this, but if this thing gets passed, you only cite the guilty ones. Don't cite the landlord, and if you can't figure out which tenant did it, then you can't write a citation. Thank you.
Hi, my name is Louis. I'm strongly opposed to the ACE ordinance. I made the horrible mistake of voting for Carmen Chitanich. Now I feel horribly raped and violated by him through his fascist ACE ordinance. I've never seen anything like this in the city before. It has to be stopped. Right now, housing providers have to deal with SCEP, REAP, IMP, every other ordinance in the world, and now we have to deal with ACE. This will just put us out of business. The city does not need us right now. I'm telling you, there will be riots in the streets over this ordinance. You cannot pass this ordinance in the city. There's no due process. It's not constitutional. There's something that smells really fishy about it. I'm begging you to put this ordinance, just gut the whole thing. Don't even refine it. Don't even make modifications. Just stop this ordinance. It's horrible. Please. Thank you.
Good. Next. We have Frank Romero, John Villanos, Victor Verchek, Kathy, is it Fed Up?
Good afternoon. I really oppose this ordinance.
Give your name, sir.
Frank Romero.
Okay.
And I feel like more and more, I feel harassed more and more and abused, sending inspectors that resemble Gestapo officers. It's coming to that point in the United States that now they come and then they treat us like servants, and you all are public servants, and now it's the opposite. They want to all they want to is milk us and rip us off with ordinance, just arbitrarily finance for no reason sometimes, and I don't think it's fair. We're not in a Nazi Germany. That's not the way the country be run. Thank you.
Let me just ask again, is Mr. Velanas here?
Victor Vierick.
Pardon? He left, okay. Okay, Vic.
I'm Victor Vierick. I'm strongly opposed to this ordinance. When you want to assess people for doing something wrong, first of all, you've got to let them know what the ordinances are that they would be violating so they don't violate them. And then, again, with apartments, considering a rent stabilization ordinance, you need to assess the people who are causing the problem. And with the rent stabilization ordinance, the tenants do it and the apartment owners get stuck with it when they weren't even at fault. So that's part of the problem. Another part of the problem is if you're trying to raise revenue, this is really a dumb way of doing it because you're scaring commercial business out of the city when you assess them without letting them know what you're going to assess them for, and then you go ahead and assess them before they even have a chance to correct it. You're going to lose business, lose a lot of revenue that you could have made, and it's going to cost you more money in the long run.
Thank you. The last two cards, Monique Byer and Stephen Box.
That's not me.
No, you already called your name. Give us your name.
Okay, I did not give you my real name because you guys scare me very much.
Oh.
I am now
So
very
you must
afraid.
be Kathy Fed Up.
Yes,
Okay.
I put fed up.
How do you spell fed up?
That's how I am.
How do you spell fed up?
F-E-D-U-L.
F-E,
Oh, okay.
exactly.
I didn't see the card.
Fed up.
Okay.
And I'm really worried about you, and I did not expect that America will turn this way ever. I came to America because of freedom, pursuing freedom, and I did not. You guys are taking it by the day from me. All your new laws are there to persecute us taxpayers. You are treating us like enemies, and you are creating enemies all around us. You have taken away our peace of mind. There is no way for us to fight back against you. We are cornered. Anyone can create a problem on my property, then snitch on me and get me in trouble. This is a way for you to steal from me so you could waste more of my hard-earned money on whatever you decide to waste it on. What you are doing has a name, ladies and gentlemen. It is called tyranny. Our ancestors must be turning in their graves seeing what you are doing to us. Stop persecuting us business owners. We are the backbone of this country. Your laws are unfair, if not criminal, and we demand that you stop the abuse.
Thank you very much. Is Monique Byer here? Okay. Put her name in, Mr. Box.
Good afternoon. People around the city are celebrating the ACE program because they think it's going to stop their neighbor's dog from barking or that loud party from making noise. But the brutal reality is that it addresses conditions that they may have inherited long before they bought their home. In East Hollywood, there are 177 homeowners who are currently under threat of lien, garnishment, and criminal action simply because they have over-in-height fences, many of which were there before they bought their homes. This particular ordinance is so sweeping in its scope that I think people forget that it's going to, or don't realize it's going to address broken sidewalks at some point in time. It's going to make it easy to prosecute the people who have invested in our communities, and at the same time make it difficult to avoid encumbering their properties and their possessions with liens and garnishment and threat of criminal action, all because the city attorney's vision of this document or program is much more excessive than I think what you originally envisioned. So I ask you to reconsider or reject the ACE program as proposed. Thanks very much.
Thank you. We're going to have the city attorney and the CLA to come up this time. Pete, could you, as you go through the elements of the ordinance, if you can comment on some of the comments that were made before you came to the table, and as far as relates to some of the issues that were brought up?
If I may start out, Mr. Chairman, Pete Echeverria from the City Attorney's Office. If I may start out with the direction that we were given last week, and then I'll go through the ordinance briefly. The CLA's report last week raised a number of issues that the committee asked that we discuss with them and resolve and bring back to you in a revised draft ordinance. We have done that with respect to, I believe, virtually all of the issues. There's still some question about the subpoena power that the hearing officers would have. We have defined and limited that to the extent possible while still leaving a subpoena power there. It's ultimately a question of policy for the council to determine, for your committee to recommend to the council whether or not that subpoena power remains as part of the program. It was intended from the beginning, and it is now more narrowly defined to provide some degree of protection, essentially for the person about whom the complaint has been issued, the defendant, if you will, in the case, to be able to obtain records or testimony that they otherwise don't have or can't get, and the hearing officer would be given the ability, when requested to do so, either by that party or by the enforcing department, to issue a subpoena for that information, and only if the requesting party established to the satisfaction of the hearing officer that the information was required for resolution of the matter and was in fact relevant to the matter. That criteria would have to be met. That's still in the ordinance. Again, it's a policy recommendation whether the committee wants to recommend it to council or would have that removed. The ordinance itself establishes, it's fairly lengthy and complicated, but it essentially established a process by which administratively the matters that are now handled as either a misdemeanor or an infraction under the code can be handled administratively. By the issuance of a citation, the party who receives the citation can either come into compliance and pay that citation, or can ask for a hearing, a review of the citation and a hearing. The citation is initially reviewed by the city attorney's office, as we do with complaints that come to us from LAPD and numerous other departments, and we make a determination of whether or not there appears to be sufficient evidence to establish that there was a violation that occurred. If not, then it's rejected, and the matter goes no further. If there was a violation that occurred in the minds of our deputies who review this, then it would be set for an administrative hearing. The administrative hearing officers would be selected pursuant to policies and procedures that are required under this draft of the ordinance to come to the council and be approved, so that it is assured that those individuals would be indeed impartial, neutral decision makers who would then hear the matter, and then they would have the authority to, contrary to what was said earlier, to have the department establish that the violation occurred, not the person about whom the complaint is issued. The burden is on the city to establish that. If it's found that the complaint or the violation did not occur, then the matter is dismissed. If it's found that the violation in fact did occur, then the hearing officer can do a number of things. They can either affirm the amount of the fine or can reduce it if there is evidence that there was some mitigation, such as that the person has come into compliance now and has taken other efforts to resolve the situation. That's essentially how the program is intended to work.
Thank you. Let me ask the CLA. We asked before at the last meeting that you and the CAOs, the city attorney, sit down together and resolve what the conflicts are. Are there still conflicts as to this draft as opposed to what we were discussing last week?
Mr. Chair, Roy Morales with the CLA's office. We've raised 14 issues in a report that was presented to the last committee meeting. We worked closely with the city attorney's office on those issues and are pleased to say we were nearly unanimous in coming to agreement with them. We still have 2 areas of concern. However, they are significant areas of concern. I believe, and we've discussed these with the city attorney as well. The first issue is with regard to the definition of administrative hearing officer. The city attorney did tighten up the definition, as you can see on page 3 of the ordinance, in that the administrative hearing officers would be independent, neutral decision makers. However, the definition includes examples of the types of administrative hearing officers rather than a definitive list, if you will, of the types of individuals who would be appointed by the city attorney. The second issue is, of course, with regard to the issue of subpoena powers. It was clarified for us by subpoena power, Mr. Rosenthal. It was clarified for us as far as the authority for subpoena power that exists in current law and the authority that would be granted to the hearing officers in these hearings. We have some concerns about that, in that the authority, let me try that again, the granting of subpoena power to a list of hearing officers who are not defined would leave it open possibly to open interpretation as far as how those subpoenas can be used. There are some safeguards that were built in. However, the charter currently specifies who has the authority to issue subpoenas in the city of Los Angeles, and we do not believe that in the pilot phase of this program that it would be necessary for that authority to be granted to these hearing officers. However, we do recommend that that issue be resolved, or I should say be tracked during the pilot phase to determine if it's necessary. We are supportive of the program. The CLA's office supports the Administrative Citation Enforcement Program with those concerns.
Let me ask you, you commented on subpoena powers currently by the charter. Who does have subpoena powers?
I believe under Charter Section 217, the issue is City Controller, the City Treasurer. There's a list of them, but most of them are done through, issued through the City Clerk's office on behalf of the departments. Currently, for example, the Civil Service Commission, if they have an issue that they need a hearing, a subpoena issued, they request that the City Clerk issue the subpoena on their behalf. Boards of Rights, I believe, also have that authority as well.
If I may, Mr. Chairman, the charter actually provides that any hearing officer that is delegated authority by a city commission to hear matters on their behalf and then to make a recommendation to them, it has subpoena power.
Okay. That's what
through the issuance of the city clerk. So, for example, the Civil Service Commission is one, and the Police Commission, they have hearing officers. There's a list of people who hold those hearings. They have subpoena power as well.
What about the charter as it relates to individuals or other elected officers?
That authority is given to the council as a body and also to commissions. And in addition, I believe the controller.
Mr. Chair, I believe it's the mayor, the city controller, the treasurer, and the council, and the civil service.
Speak up and read those.
I'm sorry, microphones. Charter Section 217 gives the city clerk the authority to issue subpoenas on behalf of the mayor, the controller, the city treasurer, and the council, as well as the Civil Service Commission and the LAPD and the LAFD Boards of Rights hearings.
So it specifically says the controller is one of those entities?
Correct.
Yes.
But all of them are issued in behalf of those entities by the city clerk?
That is correct.
Okay. Mr. Kretz, this is your motion.
Yeah, I think we all talked about the reasons for this program being created last week, so I won't discuss it again. Just a couple things. Again, I want to clarify and correct me if I'm wrong that this will be starting as a pilot program either with just the police or just the police and animal services.
No, if I may, the police department is the first department that comes on board. That's the only department initially. There are 3 other departments specified that can come on board after there's a report to council on the implementation to date and the progress with the police department's participation in that program.
I would submit that there are some loose ends and some concerns that haven't been resolved that have been expressed over and over here today. And I believe we can meet with all the stakeholders and work those out before this moves past the first phase with the LAPD. And it certainly would be my intention to do that.
There are several things that must occur before the program is actually implemented. One, obviously, is that the ordinance must be adopted and go into effect. But beyond that, after that, the ordinance goes into effect, there needs to be the policies and procedures for the holding of the hearings and for the selection of the hearing officers must be submitted to council and approved as well. There's a significant, I think, window of time for other things to happen.
And even after that, we will be starting as a pilot with just the police. So questions that are more housing related will have an additional period of time as that part is implemented to then continue to refine the rest of it.
Yes.
Okay. Couple other issues. The signage issue was mentioned, and the fact that we have other signage regulations coming forward on a parallel track. Would it make sense to pull that piece of this out and add it on at a later time when Plum has heard all the signage questions later this month?
With all due respect to the speaker, I think it would make sense to include them and to amend them as we go forward. We're very much aware both of the ordinance that's going forward before Plum and of the provisions in this ordinance, and they would be made compatible at that point.
So if Plum came up with something that was in conflict of this, we would just have to amend those regulations to meet what they had already done.
Correct.
So you don't see any harm in moving forward now.
I do not.
And obviously, as a pilot program, actual enforcement of the signage piece of this would be anticipated to be quite far off in the distance anyway.
Yes, it's one of the subsequent departments.
So that, again, is something we could amend afterwards to come into agreement.
Yes.
And how problematic do you think would be not having subpoena power from the beginning as opposed to not having it tracking the number of complaints about inability to get information and seeing whether we needed to tweak that in the future, which is what's being proposed?
It's not problematic in the sense that the program cannot operate. The program would go into effect and would operate. It's a question of fairness to the person against whom the complaint is filed. There might be situations, and I don't know what the number or volume will be. Perhaps that pilot program will tell us, where there would be complaints about not having had a fair enough hearing because they weren't able to obtain those records. I might point out that even if the administrative citation is sustained, there's also a procedure to go to Superior Court and challenge it. So that would be available as well.
Okay, well, just FYI for my colleagues, I'd certainly prefer that we have the subpoena power in this, but it wouldn't be a deal breaker for me. I think the process will work either way.
Okay, you finished, Mr.?
Yeah.
Okay, a series of questions for the record that I want answers to, and then I'm going to make a comment, okay? What is the difference between the administrative citation and a notice to comply? What's the difference?
The administrative citation would be actually the imposition of a fine and the penalty. A notice to comply is what is issued by the department when they go out and they make note of the violation and they say, you really need to come into compliance. Here's the requirement. You need to come into compliance. And if you don't, then the subsequent step would be either to refer to our office for prosecution or the issuance of the administrative citation.
So the first step would be to give them a warning about an issue before any kind of a citation would come forward?
Correct.
Second question is, the ACE program will be driven by resident complaints. Is that correct?
I'm sorry?
The ACE program will be driven by resident complaints.
For the most part, although there are inspectors that the city has who will go out.
But for the most part, it is neighbor on neighbor.
Complaint driven.
What code sections will be enforced through this program?
I think maybe Tina Hess, also from our office, may have something to add to that last response.
Good afternoon, Councilman.
Your name for the record?
Tina Hess with the City Attorney's Office. With regard to whether a violation or a citation is generated for a violation pursuant to a complaint by neighbors, there's no difference between what's proposed under ACE and that which exists currently within the code enforcement departments. As I think we're all aware, building and safety right now is primarily complaint-based in terms of code enforcement. Nothing would change. On the other hand, the housing department, for instance, is not typically complaint-based. However, a portion of their enforcement efforts are complaint-based. The majority of the housing department's code enforcement program is pursuant to the systematic code enforcement program.
Okay. What code sections will be enforced through this program?
The ordinance provides that as the department has added a list of the primary code sections that would be enforced through the program, it would be provided to the council, not exclusive and not limiting on the department, obviously, because you don't want to hamstring their ability to use this less onerous process for enforcement, but the council would be advised of those. So, for example, even without that, there's already been a policy recommendation by this committee to limit the Animal Services Department's participation only to licensing violations at this time, and the ordinance is written in that way. When they are brought on board in the second part of the phase, or the second phase of the program, they would be limited to those types of violations.
Yeah, I wish that was the case with the Animal Department. It isn't.
Right.
They go out and they cite a lot of people with their dogs because they're off the leash at the moment.
But they could not use ACE to do that.
Are the codes selected by the city attorney's office or by the department head, or both?
We're basically not an enforcement office. We're tied to enforcement, but the departments would be the ones that do the selection of those codes.
And would that go through a public process for us to discuss, or is it automatic because the codes already exist historically?
You've already adopted the municipal code, and so the codes already exist. This program would not expand upon the types or nature of violations that the departments enforce. It would just give them another mechanism to do so.
My fifth question is, please explain the fee structure on page 5 of the draft ordinance and how these fees were determined.
For those fees, and the ordinance is fairly explicit with respect to the fees that are misdemeanor, not...
You see the chart?
Infractions, infractions. The fees were determined by looking at the maximum penalty that's provided for by law for them, or in some cases where there is no maximum penalty, a suggested amount. But where there's a maximum penalty provided for either a misdemeanor or an infraction, that's what was utilized.
You know which ones were suggested that are fresh in that regard rather than historic?
I personally don't have those. I can provide those to you by the time, before this goes to council, but I don't have those because I didn't prepare that schedule. I'm sorry.
Are the fees for the signs listed on page 6 consistent with the fee making their way through the planning committee?
They will be made consistent with those. We understand that there is an ordinance that's going through Plum. As that ordinance goes through and as the council acts on it, this would be amended to reflect that. That would be, we anticipate that would be prior to these fees being enforced under this ordinance, because again, it's a phased program, and building and safety and planning would not be part of this for quite some time.
Well, I have great respect for my colleague, Mr. Koretz. I cannot support this today for several reasons. One, this new one, this new draft came out today, and it is a significant impact on a lot of people in this room and outside of this room. We need plenty of time to take a deep breath, look at it, have interaction. I think you should meet with the AGLA crowd and others and have discussions about these issues. I can tell you, since I've been on the council, I've been trying to figure out a way to bring into grandfather strategy for 75,000 illegal units. I don't want to get rid of the illegal units. People are living in it, and we don't have enough affordable housing in this town. What I want to do is bring them up to health and safety issues, but deal with the reality that people are living in there and we don't have enough housing. And that issue has not gone anywhere because of the concerns about how do you do that. I also, since I've been on this council, cannot believe this fence and hedges business. All it does is create McCoys and people shooting at each other, which is another issue that has been on hold indefinitely because nobody knows what the hell to do with it. It's a real big problem. But this particular moment in time, I need to study this more. I think the community needs to study it more. And I think we need to have this process before anybody does anything so clearly understood by all of us that we're able to participate in a meaningful way. And I say this with great respect for George Wolfberg and for Haldis Talpas, who are dear friends of mine. It's half-baked today, as far as I'm concerned.
Yeah, I just had a few questions. And first, I want to say that I think in concept, the ACE program could be a very good one. I think in concept and looking at the structure, particularly in what the police department can get out of this. But it's not just a police pilot. I mean, it's being sort of packaged, from my understanding, as a pilot, starting off with the police department with LAPD. However, we would be passing the ordinance to include all the departments. We would just phase it in upon some type of, it's not really spelled out, so I'm not sure when that phase-in would be. My concern really involves the administrative hearing officer and trying to figure out who that would actually be. And according to the ordinance, it says here, a neutral decision maker, such as a pro tem judge or superior court or administrative law judge. It doesn't say exactly who specifically that person would be, and would they be a city employee? Who's paying for that? I haven't seen the cost estimates on actually operating the program. Just the new ordinance, which came out today, I believe, at noon. So can you focus a little bit on the administrative hearing officer? And
Yes, I'd be happy to. The concept of the administrative hearing officer and the cost hasn't changed any since it was first proposed. The definition...
It's never been flushed out and spoken out publicly either.
Correct.
So that...
Correct, although, and that's something that would be addressed, I believe, as the policies and procedures for the appointment of those individuals is brought to council, and council approves those. So that's one of the steps that is yet to be taken.
Okay.
With respect to administrative hearing officers, they are not just by virtue of the ordinance, but by virtue of court law, they are required to be independent, neutral decision makers.
Are they paid or voluntary?
They're paid.
They're paid.
They cannot be influenced, however, by either the office, the prosecutorial office, or by their employer. They have to be independent in rendering their decisions. That's case law as well as, I say,
So we would still be
administrative
flushing
law.
out the actual cost of the program. What we would hope it would be cost neutral. It'd have to be cost neutral at best.
I would think so. I would think that's something that the council would be concerned about. I also believe that the cost would be relatively easy to define, since we have a number of other programs, such as the one in the police department. We have a program at DOT, and housing, where there are hearing officers, so it might be possible to flesh that out relatively easily.
And starting off with a pilot program, which it's really not. It's implementing over time, perhaps, versus calling it a pilot program, because we'd be passing the entire ordinance. But if we started with just LAPD, on the heels of realignment with the state of California and bringing in 4,000 new low-level realigned offenders to the city of Los Angeles under what I would really call derailment, not realignment, LAPD is going to have their hands full in the immediate future to try to keep crime low. I think these are great in concept that need a little more flushing out. It's sort of the equivalent as if we're building the boat, we're putting everybody on it, and then we're going to see if it floats.
Well, if I may, for the purpose of clarity, the way the phasing is spelled out in the ordinance, yes, police department would be first. The recommendation the instruction that we got last week from the committee was that there be at least 3 other departments that would come in the second phase, but not until there was a report given by the city attorney as to the progress and the experience thus far with police departments. So there would be a report.
Those would be progress reports. However, the ordinance would already be adopted, and therefore it would be up to the departments to start their other process.
They could not start until council received that report and approved it. And then, as to those 3 departments, as to any subsequent departments, council would have to explicitly approve the participation of any other departments under the program. And it could not start until there was prior approval by the city council.
Is there, since this is the budget committee, is there a cost-benefit analysis, or is there a cost for the program? Any type of financials that are being presented?
Not by our office, and I don't understand that the CAO has been asked for that yet.
Well, I think we need to see that, to see what we're getting into and all the costs for bringing this kind of program, what kind of cost factors we're looking at. Training, I mean, there's a lot of different costs that have to be spelled out to implement a dramatic change like this. I think, again, I go back to this, I think in concept it sounds interesting, and I think we have a lot more work to do on it, but the cost particularly now when we're looking at perhaps another $200 million budget deficit.
Again, for example, the costs for the hearing officers, what we're anticipating is that we would, once the ordinance is adopted, because the Superior Court won't even talk to us until that happens, would be with the Superior Court to ask them to identify no-cost or volunteer hearing officers for us to utilize in the program. So that's in the future, but that's what our intention is.
But there's going to be caseloads that if we just have volunteers and we can't get volunteers in, and then we have to hire staff because we don't have the volunteers, and under due process, they have so much time because they're entitled to a hearing. I just see problems with that. So looking at, there are a lot of different costs in terms of training and reprogramming, tracking the citations, systems that departments don't have. LAPD does have that. A lot of other departments don't have that capability. What is it going to take to bring those online? I'd like to see some of those costs flushed out as well.
Thank you, sir. Let me just go through a couple of things, and I think from listening to Mr. Englander and also Mr. Rosenthal, we just received this a couple hours ago. Let me just go through a couple of things that after reading this over and over again, trying to figure out what would be best in light of this program. A couple of things I'd like to see if we can get a response on. What is your goal in the sense, I don't know if I have the right term that you called operational plans would be forthcoming to tell us exactly how the program was going to work. When would that occur, and what would be the depth of that report?
I don't have an exact timeline. We would do it as expeditiously as possible. What the ordinance calls for is for the policies and procedures for the carrying out of the hearing, first the selection of the hearing officers, and then the carrying out of the hearings themselves to come to council and be approved by the city council.
Would that be where we'd get a clear definition of what a hearing officer was?
We would certainly know at that point whether we had a source, if you will, of volunteer or other hearing officers from the Superior Court. But yes, that would be much better defined at that time.
Okay. Have the city attorney met with the CAO as to giving any kind of cost analysis of the program?
We've had a number of discussions with them, but I don't think it's gotten to that detail level.
Okay. And then one of the things I was going to ask, in reading the report, it also reflects that the person that's being cited does not have to even sign the citation. How do we get around the issue of positive ID if we're going to be going through a hearing process or eventually maybe even liens and suits? So I know we had problems years past about field release because it wasn't a fingerprint, you didn't know who the people were. So how do we get around on positive ID that the person who shows up with the citation we can verify is the one we issued it to?
It is obviously incumbent, and it would be the obligation of the city at the hearing to establish both that is the individual that committed the violation and that the violation occurred.
Okay,
the burden is on the
person
city.
that did the citing?
Yes.
Okay, because one of the things also in the later part of the report, it actually says that the citing officer may show up, but is not necessary. So who would do the verification of the citation?
I think what happens, for example, in traffic tickets is if the officer doesn't show up in court, the ticket's dismissed.
I know, but in the ordinance, it actually says that they may show, they don't have to show up. It says they may be there. It didn't give a shell. And I'm just trying to figure out where does that identification come from if you're giving them the latitude of not being there, but then the positive ID.
Councilmember Parks, Tina Heskin, City Attorney's Office. The issuance of the citation is just the same as if it might be if the individual was being cited for an infraction or a misdemeanor. The officer in the field, whether it's police department or inspector, would examine that person's identification and issue the citation accordingly. Since the underlying violation is a crime under the municipal code, if the individual did not have proper identification, the officer would then make the decision whether to arrest that person for an underlying violation, typically a misdemeanor, sometimes an infraction, or not.
Okay, but I thought, maybe I misunderstood, I thought our whole purpose of this was getting this out of the criminal system and that we're coming up with administrative. And I think the dilemma is if we now are saying that an officer, whoever cites, is a person that, if you don't have ID, I can now arrest you.
The same power that they currently have under the municipal code.
Okay. So it's not just this could lead to a criminal prosecution starting off as an administrative evaluation.
If I may, it starts out as a violation. Okay. And there are now two alternatives for citing and enforcing that violation. They are either a misdemeanor or an infraction. This just gives a third alternative for enforcement. The violation is the underlying occurrence.
Let me ask Office of Finance. I think when your office was here last week, we asked about a process to collect the fines. Did you get any headway on that?
Yes, actually, Ed Cabrera, Assistant Director, Office of Finance, we initiated a discussion with the Controller's Office based on the feedback we obtained from this committee last Monday. That discussion centered around our recommendation that the administration of what is being proposed as a code compliance fund be funneled through the FMS project. We've had that initial discussion with the Controller's Office. There are some concerns on both the part of the Office of Finance as well as the Controller's Office, and we believe that there's much more extensive dialogue that's necessary, not only between the Controller's Office and the Office of Finance, but as well as the CLA, CAO, city attorneys, and other impacted city departments.
Is that going to cause a reprogramming of FMS?
Potentially it may, and I would defer to the Controller's representative that's present. But we've looked at the limitations that are inherent within the Office of Finance's LA tax system, which is geared towards the collection of data regarding businesses. We've also looked at the significant programming hurdles that would have to be undertaken in LA tax, as well as the diversion of tax collection resources that presently serves the core function of finance. And it is our belief that tailoring the program to run through FMS is perhaps the most viable option available, apart from having each department administer their collection process themselves.
Okay. Let me just ask also, Pete, did the city attorney's office look at the prospects that, particularly with, if we're starting with LAPD officers, two things. One, if they are required to be at the hearing, is that then overtime, or if they're on call, as we do with court, is it viewed as the same kind of activity to be at the administrative hearing?
I know there have been some discussions with the LAPD, but I don't know the details of that aspect of it.
Okay. And then the other issue is that on the subpoena powers, the one thing I was wondering, had you looked into, if we're going to start in LAPD, the fact that their commission already appoints hearing officers, which we all kind of know what they do, whether that would be, I mean, because I had the same concern when I read your report, that you gave an example of hearing officers as opposed to what their duties. But with hearing officers, much as LAPD uses for their own permit violations or for Board of Rights, would that be an appropriate position to be the hearing officer for these administrative cases?
We believe that if the program is going to apply to any other departments besides LAPD, it would not be. There's a way, if it were limited to that department, and it were going to be limited for all purposes to that department, perhaps it could be worked that way.
The issue was not that the LAPD handle it. I was just wondering whether the type and the ability of work that they do and how they're selected, is that...
Oh, if the hearing officers could hold these types of hearings as well? That's a possibility, and I understood that the CLA and CAO were to look at that and report.
So, and if they had a group or a pool of hearing officers, would that be appropriate as far as your insight of the ordinance that you're moving on?
I think that's a possibility. DOT, for example, and housing also have pools of hearing officers that could be looked at.
Okay. All right. Let me just say my final comment is that I am also concerned about that whole planning issue, being that we're, I hope one day, getting close to an ordinance that addresses the issues of signage. and that one day we will have, get through the court process, that having that particular item in the ordinance does cause me some concern. One of the things, I think those are the issues that I have in mind, and I think Mr. Rosendahl wants to make a motion at this time.
I think I have some comments first, if I could get some in, because I think there's some things that are off base that have been said already. First of all, Mr. Englander mentioned that this wasn't really a pilot program, although he's not really listening either. I'm trying to speak to him and address his concerns. This really is a pilot program. What it is a pilot program with a skeleton added. So this is a pilot program just to do LAPD. There's no way you can transition to the second phase without full council approval and a report back on how well the program's worked, report back on all the costs. So I don't see a great concern with the other pieces because we have plenty of time to address them. It's going to be a slow process between now and the time the LAPD has been implemented and we get a report back. The second thing is the cost. There's no cost element either to this as its first phase, which is the LAPD part. The city attorney has agreed to absorb any costs. The fact is, we know other places have done this. No one has ever come up short because by nature it's creating tremendous efficiencies. You're turning a court case and a misdemeanor into a minor infraction and a ticket system. By nature, it's much less expensive, much more efficient. So I don't think there's any concern, but to the extent that there is, if there's a shortfall, the city attorney's office budget picks it up. So until we deal with the second phase, they've committed no cost to the city other than out of their budget. So I don't see the great concerns. I have all the same concerns over issues that Mr. Rosendahl does, but I believe they can be addressed between now and the time that those issues would be addressed. Right now, while it's an LAPD pilot, I have no concerns about these other issues because they're not going to come into play. I think we have plenty of time to hold those meetings and to address the problems, and I am concerned about the same problems. There are certain violations that I don't want to see us focusing on, and I think we have to find some way to address it. But right now, moving forward, I see can do no harm and can only do good in terms of addressing some of these minor violations in an appropriate way with the LAPD pilot. I agree with Mr. Parks. I just as soon remove the signage piece because I know we're going to amend it almost immediately anyway. If we don't, I don't think it'll matter that much because we'll amend it long before we ever have to enforce it. So I'm willing to go either way on that. The rest of it, I think we're ready to go. And I don't think we'll do any harm to anyone. We'll start enforcing things that people in the community have been asking us to enforce for many, many, many years without any success.
Let me ask Mr. Echeverria. First time I heard that your department is willing to absorb the cost. Is that
I believe they've said that in prior meetings, so I'm just repeating what I think they've said.
I just want to hear it on tape.
I certainly have not been at meetings where we've made that commitment. We can look at that, but we have not been at meetings where we've made that commitment that I know of.
Well, that was my understanding.
I can check that.
If I could, I just want to define just a couple things for clarification. And as I said, I think in concept, this sounds good. In terms of LAPD, I think there was a lot of questions that the chair brought up as well that I haven't heard addressed in terms of do they have to show up on overtime, these hearings for due process. I don't think those things have been addressed. But the real question that I have is really the splitting between pilot and phasing. Because I think people hear the word pilot program, and to me, pilot means we're going to try this out. We're going to try it in one council district. Mr. Kretz is going to start off for 6 months. In one council district for 6 months to see it. That's a pilot program. We just finished a pilot program with a recycle company to see if it would work. It didn't work. We're not going to continue it throughout the city of LA. That's what a pilot program is. This says a phasing program. We're actually going to phase in, and then it goes on. We're already excluding. Well, let's take the signs out because we're still dealing with that in the Planning and Land Use and Management Committee, so therefore we can't really do the signs yet. I've got questions on the planning in terms of the chart on page 5, number 2. I'm not sure if this deals with expired temporary certificates of occupancy, or it just says for which permits or approval are required but were not obtained, or land for which no permit could have been obtained. That means their fine would be 4 times the amount. Does that mean, for example, an illegal wall where they didn't get a permit could be 4 times the amount? Some of these things need to be flushed out a little bit, but it doesn't matter, because if it's a pilot program and it's only LAPD, they don't write citations for walls and those kinds of things now anyway.
Hope not.
So not yet anyway.
Not yet.
Unless we go back to 1911, but that was another issue. I won't go there yet. But in looking at this, this is not a pilot program. This is a full-blown change in ordinance to implement in phases. And so I just want to put that out there, that the way I read this is not a pilot. And again, in concept, I think a lot of it is good in concept. I think starting off with a pilot with LAPD for the things they're already doing, loud noise. I mean, I'm a reserve LAPD officer. I've been out there where you do hope that you could write a citation for something like that, and you're not writing somebody a criminal offense, that if they're applying to become an LAPD officer or a firefighter, or particularly during this unemployment, this high rate of unemployment, they then have to document or disclose to their employer that they've gotten a citation and it's a criminal act. So if we could soften that with an administrative fine and make it easier for officers to cite for those kinds of things, I think that's one thing. But again, if that were a pilot, this is a phasing in of a program. And so I don't think we're ready for the full-blown program yet.
Mr. Parks?
Yes.
I think it's almost what you say. It is a phasing in, but if we don't like it after the first phase, it's over. It's absolutely a pilot project. There's nothing that says you go forward with the next phase unless it's approved.
Does the first phase have a sunset?
No. But if we don't like it, we just vote to cancel it. There's nothing that automatically moves it forward. In fact, there's a very clear process that makes us get a report and approve the next phase. If the thing loses money, if it winds up being problematic in other different ways that we didn't expect, we don't move it forward. So that's what makes it a pilot. But it's a pilot with logical next steps. So we don't have to waste, many, many months debating things that will already be in place, a skeleton that's already in place for the next phases, if the program works.
Excuse me, it is phased in, and it is under the control of the council, fully under your control, whether or not it goes to the next phase or not.
That's what scares me the most. Have you met my colleagues? I mean, really? In 2 years, we'll have 6 new members, and they weren't here for these discussions,
Right.
And then all of a sudden, the departments are saying this is working. I mean, it's one thing, I think I go back to this. A pilot is one thing, phasing in is another, and I just wanted to clarify that.
And if I may, with respect to the Office of Finance, the way the ordinance is written to include them as the both administrator of the fund on behalf of the council, because the fund is under the control of the city council, but it also imposes on them the obligation to work with city departments and the city attorney to establish a system for both the receipt and the deposit of all the receipts required to be deposited into the fund. It doesn't tie them to being the office that actually receives the money and deposits it. It's that they need to work with the departments and figure out how that's going to work and how it's best for it to work for the city.
And if I could just close this one last thing then on that. I'm not trying to throw the baby out with the bathwater from my perspective. I think a lot of this is very good. In fact, the number one complaint we get, besides the city, but outside of that, to our office, is the quality of life issues in our district. And that is really some of the neighbor against neighbor issues, and that they're not maintaining their properties, whether those are residential properties or commercial or retail properties, and code enforcement doesn't really have the ability to easily cite them. If we come back and look at actually phasing in a pilot program, if you will, that we can look at just the list of what kinds of things they would be citing under that as well, because I understand you've mentioned earlier that it would be up to the departments to figure out what they already have on their books, that they would decide then what they would want to bring into the ACE program. I think
No,
there's
I'm
just too
sorry.
much wiggle room.
I'm sorry, the ordinance requires that a list of those sections that would be primarily enforced, it's not,
Which we
wouldn't be a
don't have-
limitation.
we
on
don't
the-
have that yet, though.
That you would have that before a department is added.
Well, I'm just not ready yet. I think it's half-baked today. It's not ready for prime time. Next time, I like to keep it in committee, but I'd like to have the LAPD come in and give me their understanding of what this means from them, from an enforcement standpoint. I'd also like to have the clarity of what we're really looking at doing with the LAPD within that timeframe. And I'd like to continue that healthy discussion. But I make a motion that we continue this item until we get more clarity on it, and if there's any more paper that we're supposed to get, that we get it in a timely manner so that we can read it and
I have to tell you that the CLA in our office worked hard and diligently to get this done within the week that we were given.
I know.
The revisions
Maybe you
done.
should have had a couple of weeks to begin.
So I'm happy to do that, make our best efforts to do that, and I apologize that it was as of today, but we did work on it. In fact, I
I
worked through the weekend.
apologize, too, for even saying it, but the point is, we get at 10 o'clock in the morning, and we happen to have other things we're doing at the same time. I get it yellow-lined in a couple of notes as best I can do it, but frankly, this discussion has been healthy about where we are and what we're doing. And I go back to some of my original comments. I really don't like neighbor against neighbor unless it's a clarity issue on something that's so clear as an issue. And I think I'd like to leave it here and continue to have this conversation. LAPD?
Yes, I'm Commander George Villegas. Good afternoon. We have been working with the City Attorney's Office. We have a list of sections that we could use. We haven't decided definitively which of those sections are that we could use, that we would use as part of this pilot program.
Okay, and would that be coming to the committee so we can actually see what you're talking about, not before council, but before the committee, so we can shed some light on it? That's what I would like.
At your direction, we can do that for you.
Okay, that's my direction. I'd like to see it.
All right, let me just say, if I can assess the sentiment of the committee, that we will hold this in committee, but there's a number of things, if I've captured the sentiment also, that we would need the next time this came forward. Number one, I think we need the clarity from the CLA as to exactly what the charter's responsibilities as to subpoena powers. We'd asked the CLA and the CAO and the city attorney to work and come up with a more definitive definition of administrative hearing officer. We'd also asked the CAO to give us some form of a cost analysis. As the city attorney has said, they do not intend to absorb this cost, but the cost analysis for the hearing officer program, or if there's a need for additional personnel. I think also we would need in this ordinance some clarity as to the positive identification of those that are being cited, so that we're not wasting time with giving out a citation and not knowing who the people are. The issue also that we want to ensure that the Office of Finance and the put forth a appropriate system to collect these fines, because there's no reason to be citing if we're not going to be collecting those fines. I think we need to have the clarity of LAPD and the city attorney as to just what are the overtime commitments if LAPD officers are called to these hearings or are placed on call. We need also to ask LAPD to provide what would be their tentative listing of violations that they would recommend as part of that review. That we also ask for the clarity that Mr. Englander asked for in the relationship of having a pilot versus phasing in program, that we address the planning issues and the pending ordinances for the clarity of those particular issues so that we're not in conflict, and that we also get more details on the policies, procedures, and the operational plan that the city attorney articulated that they would be moving forward on. And then my final recommendation is that we ask during this time that the city attorney work with LAPD to determine whether the current system of selecting hearing officers in their department would be a viable means of using those pools of administrative hearing officers in this process. I think I've tried to capture each and every concern that has been brought up, and we'd ask that the CLA and the CAO and the city attorney make us aware as a committee when we would bring this back with those questions answered.
Mr. Chair?
And LAPD, yes.
If we could have a date certain before we leave here, I think that would be good, because we have been working on this for something like a year and a half, so I don't
Let me
want
ask
this to
CLA,
drag.
do we have give us a projection?
The next scheduled hearing is actually October 17th, so we can...
But let's not do what we did last time. We asked about 12 things for you to do, so what's the timeline that you think is appropriate?
With publishing it so others can see it, the LAPD clear about what they're talking about, all of that.
Hearing from the CAO. 30 days, we will report back.
Okay. And let me ask you this, is that, Mr. Rosendahl, you talked about community process. Is that something you intend to do locally, or are you asking the CLA to participate?
I would love for the CLA to do it, to do an outreach with the community and sit with these folks, some of them that we hear, and understand their point of view as part of the process of doing outreach. You don't have to agree with them, but it would be helpful to hear it and to understand it, react to it, and bring it to our attention back in the council and committee meeting when we meet, that you've done that kind of work.
Councilman Rosendahl, would that be on the LAPD portion or the entire program?
I don't think you separate them. I think the ordinance is the ordinance, and then LAPD is going to be phase one. I think you'd have to have,
In all fairness, though, I think nobody has complained at all throughout this process about anything that the LAPD piece relates to. So I think if we're talking about the community, we're probably trying to reach property ownership, housing type issues.
Well,
So
I don't know.
That's the direction we're looking at.
I don't know how you can have community outreach without using the ordinance as a basis.
Right.
So with those directions, and you're saying from the CLA's office, you report back in 30 days?
Yes, sir.
Okay, thank you very much. Next item.
I don't know what happened. Roy.
Okay. Yeah. Next item.
Okay, next item is actually item
We ask
11.
everybody if they can continue their conversations outside,
11,
please.
yes.
We have two more items on the agenda.
Item 11 is a CEO report relative to requesting approval of a list of qualified firms for underwriting, remarketing, investment banking, and other related services for city bond programs.
Okay.
Toe is here to present the report.
Oh, good.
I believe, yes, the clerk is passing out a chart of all of the underwriters that have been utilized over the last 2 years of the list, prior list.
Wow, activity. Good afternoon.
Good afternoon. Hato from CEO office. In April, the CEO released a request for qualifications for underwriting, remarketing, investment banking, and other related services for the city's bond financings. We sent the RFQ to 58 firms. We got 39 responses. After an extensive selection process, the CEO recommends approval of a list of 22 firms by pools and requests the authority to negotiate and execute contracts with the 22 recommended firms over a period of 3 years, with the option to extend the qualified list for additional 2 one-year extensions. Firms may change their roles or participation in the municipal market at any time, and it's not possible to predict when this will happen. So we recommend to maintain the qualified list by adding or deleting or modifying the firms from the pools if any one of the events occur, if the firm exits the market, if there's any mergers or acquisitions, if there's any changes in their underwriting capacity, any significant changes to their team members, or any other event that may alter their ability to provide underwriting services. The last list expired in July, and in the past 3 years, the city has completed 23 bond financings. Of those 23 bond financings, four were competitive, and 19 were negotiated sales. Of the 19 negotiated sales, 8 were senior managed by large firms, and 11 were managed by the small to medium firms. And the new list that we are proposing today, I think will continue to allow us to utilize the small and the large firms to give a good mix of services and the strengths that they provide. If you look at attachment 3, it's towards the end of the report. You'll see on the right side there's each pool, and you'll see that over 90% of these firms have an office in Los Angeles. And you'll also see that there's a good mix of large firms and small to medium firms in each pool.
Okay. Mr. Cardenas, you created this, so why don't you kick it off?
Thank you very much. I don't know if I could take credit for anything, but Natalie, can you come forward, please? This issue isn't fun without you being there, Natalie. But actually,
That's true.
this is an opportunity for us to be very proud of the city of Los Angeles, both the staff and the council, and the practice that we created in the city of Los Angeles. When Chairman Bernard Parks and I, after 2003, started to focus on this issue, basically the issue of diversity and making sure that qualified firms of every size have a true opportunity to participate, not only in a transaction, but actually get the opportunity to participate as a senior lead, which is basically the pilot's position for these responsibilities. And also, with all due respect, with that responsibility comes a greater opportunity for participation and compensation for your firm and the people that work for you. And when we look at the pool as it stands now, or the different pools, we now see that we have large firms, medium firms, and small firms who are going to continue to have the opportunity to prove, as they have so far during this process, to prove that they are capable. But
We
when
have
you
our
look-
first women-owned firm.
Oh, really?
Yes, Green Coast Capital Partners is a new woman-owned firm here in Los Angeles.
Congratulations.
So we are very proud of that fact.
Absolutely. And the reason why I take the time to mention that is because at the beginning, it seemed like Councilmember Parks and I were a bit frustrated and a bit bewildered as to why we couldn't shift to two things. One, to have more firms participate at higher levels, capable firms. And in addition to that, why we were a city that at that time we were practicing in competitive deals almost to the opposite percentage rate as most municipalities, large and small, around the country. When we started this effort, the city of Los Angeles was a lot closer to 80% of our deals just going out competitive. And by default, the Bank of Americas and the Merrill Lynch's and the Goldman Sachs's and a few other large firms that aren't even in existence anymore today, that they were actually able to compete in that environment, and the medium and small firms all but just opted out. And only about 20% of the transactions in the city of LA were actually going negotiated. Now what we have is something that is more along the lines of what's happening throughout the country, and that is we have closer to 80% of the transactions negotiated and about 20% competitive. I don't think that we were in line, not because we had anything against certain firms. Unfortunately, there were some circumstances that occurred some years ago, a few decades ago now, that tainted our view and our protection of ourselves in a way where we moved away from a practice that made sense, but we moved toward a practice that actually excluded a lot of the medium and small firms by and large, from participating in the city of LA. And one thing that I'd like you to do, if you would please, Natalie, could you repeat what you mentioned a few years ago? We were in council, and I asked you a question about when you look at the mix of firms that we're using 10 years ago, very capable firms, and they did a fine job. And then when we saw that some large firms that had been around, their shingle said, we've been here since 1808 and 1909 or what have you, very large, very capable organizations, that some of them actually disappeared off the planet.
Yes, they did.
Some of the largest and most the firms we had a lot of confidence in basically disappeared. But when that crisis happened, we were already starting to use firms from the West Coast, from Illinois, from the East Coast, from all over the place, instead of finding ourselves, by and large, only using an exclusive number of firms as senior lead.
Correct.
I asked you a question as to whether or not the city was in a better position now to participate in the markets, and your answer was along the lines, I asked you if we were in a better position having gone through that crisis of disappearing firms that we were counting on, and now we have a much more robust list of firms that we have a relationship with who are doing a good job. Are we in a better position now?
I think we're in a better position. I think that we have, along with the state of California, because they were really the first to open the door to a lot of these firms to give them the experience, that we have a very good diversified pool, and we have a lot of different expertise in a lot of different areas, which can only help the city. You know, it's been a very good 3 years. We've done very well considering how poorly the market has been and our downgrades. We've done fairly good, and these firms have allowed us to tell our story and to be able to reach out to all types of investors. I mean, this really gives us access not only to the top-tier investors, but to the smaller investors, you know, the mom and pop, that we consider tier 3 and 4. A lot of these smaller firms have investors that, you know, are ignored by the larger firms. So the smaller firms provide us the ability to reach out to those investors too and allow them to invest in the city of LA.
And is there any drawbacks that we've experienced through this concept now that we practice?
I don't think so. I think it's been fairly good. I think that I think we've all learned to work well with each other, and we really haven't had any drama. The dramas come from the market, not from the firms themselves.
Exactly. All the feedback that I'm getting from our staff in the city, looking at the documents when we have gone out to sale, et cetera, that we've been very fortunate that everybody's been acting responsibly, aggressively on our behalf.
Yes.
And as a result, we can actually score millions and millions of dollars in advantages on certain transactions that we've actually materialized. Just, for example, by going negotiated more often than not, we've been able to pull out of the market. Remember that one time, I think it was the county was going out with $500 million. We were going out with $500 million, and then the state had just announced, I think, over $1 billion or something like that, and we said, whoa. We pulled back for a few days, went back out on the market. Luckily for us, it was still a good day. We did well, but we had that flexibility on a negotiated deal to actually look at those other activities and then time ourselves better, and we were better for it.
And I think, for example, the Tran is a great example of how it really does work. You know, we had a lead underwriter that was a large firm, but because we had 4 different underwriters, each underwriter was able to take a different portion. So, you know, we traveled to Chicago, where a medium-sized firm was able to take the lead. We traveled to the East Coast, where another firm was able to take the lead. So we really were able to use the expertise of all the underwriters. Even in a situation where a large firm was the lead, the smaller firms got an opportunity, because the city insisted on it, to be able to participate more than they normally would have, which was really good for the city. We did really well on the Tran.
Thank you. I'm almost done, Mr. Chairman. I just wanted to, again, congratulate the city of Los Angeles, because I talked to 2 California-based firms. They happen to be minority-owned, and we battled, Bernard Parks and I battled with the DWP. DWP was going to go out with a $600 million water bond and a $900 million power bond. And they were going to give the entire $900 million to Goldman Sachs. and then they were going to give the entire $600 million to Merrill Lynch. And even though Merrill Lynch, there was a California-based firm that was higher ranked on water deals throughout the country, happened to be California-based, happened to be minority-owned, they were not going to senior lead on that water deal. The council rejected that. We sent it back to the Department of Water and Power, and Ron Deaton happened to be running the Department of Water and Power at that time. So as smart as he is, he went ahead and they rescored it, and what happened was the water deal, the California-based firm out of Oakland ended up splitting the $600 million deal. They senior-led $300 million of it, which they had never done before for the Department of Water and Power. They had never gotten that opportunity. And then a city of LA County, LA City-based, happened to be minority firm, ended up getting, I think it was $350 million senior lead at the Department of Water and Power on the power bonds. Again, they had participated in many deals, never ever as a senior lead for the city of LA. Certainly not Department of Water and Power. I belabor this point because some of the representatives of those firms explained to me that after they did those deals, they senior-led some more deals with the city of LA. And just a few years ago, for the very first time in California history, 2 California-based, minority-owned firms senior-led the deal by themselves without a firm from New York, for example. They were the only senior leads. They happened to be minority firms. They were both California-based, and they senior-led a $2 billion deal. That was unheard of. And the reason why I point that out is because Bernard Parks and I and my colleagues on the council knew that once capable firms had the opportunity to prove themselves in the tough city of Los Angeles, because we hold a high standard, and we should be very proud of that, that once they had the opportunity to do that, other municipalities, other entities would notice. The state of California, it was Bill Lockyer who called those 2 firms in, and he told them, I'm going to let you 2 co-senior this deal by yourselves. Don't mess it up, because this is the first time we've ever done that. We know you're capable, etc. You're going to do a great job, and they did do a great job. But had it not been for the city of Los Angeles finally changing the way we do business, having list of firms as what is presented to us today, that would have never happened. We knew it could happen, we knew it would happen, and it has happened.
It's also
So
helped us
again-
on the competitive side, because when we do our GO bonds, some of the smaller and medium-sized firms are starting to bid on that too. So it's really, I think, helps on both sides.
Greater competition, right?
Yes.
And when we do have competition, especially when we're dealing with the tax dollar, the more competition, the better, correct?
Yes.
Natalie? Thank you. I'm done. Thank you, Mr.
Let me just comment on Mr. Cardinal's thing. When I first joined this council, as you might remember, it was DWP and some bonding issues. I truly listen and try to do what is best, and Mr. Cardinal was extremely articulate in how he clearly pointed out we needed to have a better list and a bigger list and more of a mix of a list than what we had. And he was compelling to me that I supported him on it. Somebody ran down the hall after me, screaming at me and yelling at me for doing that. I won't say who, but a very prominent person. But the logic of opening it up to everybody and giving minority groups and women groups and others a genuine opportunity is real. I also have a problem when I look at the list, though, all the usual suspects that people are demonstrating in New York against. And many of us have some concerns just right now with B of A charging us $5 for the use of the plastic. You know, some of the bigger guys that run the world, we still obviously have to deal with Goldman Sachs, JP Morgan, you know, Bank of America and all of its reincarnations and these others. So it's even healthy for us to have other options than just relying on the big boys that many of us feel are part of the problem in our country today. And I know we're in lawsuits with some of them on the one hand, but yet we have to work with them on the other because of the reality of running a city government and a budget.
Well, and we're not the ones that license them either.
I know.
So,
I know.
Yeah.
But we have to deal with what deck of cards we've been given, and we have to deal with the reality. But if the deck has more cards in it, and there's more ways in which we can work it out, obviously it's a healthier strategy for us.
well, we interviewed, Seth interviewed almost 25 firms this time, and it was, a monumental task to do that, and they did a phenomenal job of
Really appreciate it.
putting together the list.
Let me just go through a couple of housekeeping things. I want to say thank both of you. It's been a very, very long journey, and I want to thank Mr. Cardenas for putting together the bond committee that we sat on and we struggled with. But I think this report is reflective of why we put so much time into it. But let me just prepare you for a couple of questions that will be at council. The issue of responsible banking, I think we clearly understand that the underwriter firms and the banking firms have two different missions, and the issue of what is being viewed as responsible banking, we haven't clarified nor have we come up with a city policy, but we asked as much as you could to use some of the responsible banking ordinance recommendations when you put forth this RFQ. And I think could you just identify some of the things that you looked at so that it won't be the first time you hear it in council?
As part of our criteria, we did look into corporate citizenship. If you look on attachment 4, which is the last page, you'll see a list of the firms that responded and the type of charities they donate to. So you see a breakdown of it. A lot of firms donate to education. They have a lot of financial services. They donate to a lot of women empowerment. A lot of their employees also volunteer their Saturdays to charities. So we did consider this as part of our selection process, and it was also scored.
In addition, we did ask the ones that are banks, and are by law able to respond to the draft the draft ordinance. They have 60 days to report to us on some of the criteria once the council approves the list. So even though the ordinance hasn't been adopted yet, we've started the process of looking at what would that look like. And I think that will help us come up with recommendations. What we don't want to do is create a process that is bifurcated somehow. So we're trying to reconcile, the use of some of the smaller firms who aren't banks with some of the larger firms that are banks. And once we get that information, we'll have a better sense of what they're able to respond to, and, how much information we'll get. And then we can make a really good recommendation to the council on what direction we should go. Somewhere like New York or Cleveland or Philadelphia who have done this should really do good research on what's been done so we don't, ruin one policy to put in another. So this is helping us through that process.
And I agree, and I think what I would not want to see is that we get a bunch of information that we are unable to analyze and have no idea what it means, but we're just asking people to send stuff in.
Right.
I think the chart that you gave us answers one of the older CF numbers. The one thing that we also, I guess, will have at some point in the future, in fact, Beverly may be here today to just give us an update on the lawsuit that you can in public session on the firms that may have run afoul of the system.
Right, Beverly Cook, City Attorney's Office. I want to be very careful because obviously we didn't agendize it, so we have Brown Act issues, and it should also be in closed session. So I will strictly look at those entities where there's a matter of public record. And I can tell you that, for example, Goldman Sachs was dismissed from the municipal derivatives litigation. UBS has settled criminally with the Justice Department for $160 million. J.P. Morgan has settled for $228 million. Bank of America has entered into an amnesty program. And there will be something coming to you within the next several days about one of the other firms, Morgan Stanley. It's a matter of public record at this point, but we'll have more specific details about that settlement proposal. Okay. And then we can also go into greater detail about the status of the litigation itself.
Okay. Is there a planned briefing of the council for that litigation in the near future?
Yes, I've asked Nancy Nishimura, who's the the partner involved to come down personally to provide a status report. And I spoke briefly, I think late last week, and they're going to do that. So we can also do that within the next several weeks, the next 3 weeks or so.
Okay, very good. All right, let me just ask back to the CAO. One of the motions that we had a while back was asking you to figure out a way in which companies that are on our pool come up with genuine and unique ideas. How can we work with them that everything doesn't have to go out to RFP? And did we make any progress on that?
We had discussed this with the city attorney, and that's, it's very difficult because even though a firm comes up with their own idea on how to do things, I'll give you a really good example, actually. Citibank, for example, had an idea as part of the TRAN. That was proprietary. So we weren't sure, we ended up not using it, but we did is we included them in the pool, in the 4 firms that we recommended to council, and so if we wanted to use the idea, we could. And I think that kind of settles, since we have a qualified list, it's a lot easier. So if somebody has an idea, one of the ways we can choose them is to do a mini RFP, and as part of that RFP response back, they can mention that idea to us. And if we like the idea, then we can use them. But to sole source them, I think is more difficult, is one of the things that we're getting. So we've kind of worked around it by doing this little mini RFP, knowing the ideas out there, and that that it could be plausible to have them respond with everybody, and then analyze their response in everybody else's response. And if we like the idea, then we could use them. I think that's one way of kind of dealing with it. I don't think the city attorney had a problem with that.
Just explain to us also briefly, this year on the report, you create a Group 1 and a Group 2, and just how does that work?
Correct. The Group 2 list, just in case any firms on the qualified list drops out, and we want to maintain a healthy list, a number of firms in our pools, we have a Group 2 list. These firms scored at least 80 points. They just didn't make the cut because we had to draw the line somewhere on the number of firms. So if a firm exits on the qualified list, we'll just pick up a firm from the Group 2 list.
It just gives you more flexibility.
Yeah, this will give us more flexibility in terms of the number of firms we can choose from.
Okay. Now, once the council approves this, how quickly will these go into play?
Quickly, extremely. I mean, we have 2 deals that are coming up. The wastewater refunding is coming up, and also as part of the stadium MOU, we are looking for underwriters for our Mello-Roos program. And so we will definitely be trying to go out as soon as we can.
Okay. And I understand that somewhere at the latter part of this year, we may be in refinancing on a lot of our MICLA?
Yes. As soon as we're done, we're doing GO bonds. We're doing competitively, I think, in 2 weeks. We're working on wastewater. We are working on a MICLA refunding. Parking looks like it needs to be refunded. There's some savings there. And when and if the stadium deal moves forward, we'll do the convention center refunding around the same time. If not, we'll just do the convention center refunding. So that's our basic schedule. Then we think we'll do a TRAN again next year. That's basically our schedule. I think so. I'm not going to assume anything.
How big will the TRAN be?
Well, that's up to you, but how things work out. But that's basically our calendar. We figure we'll be in the market about 10 times till the end of June. It's a busy, because of the refundings. I mean, interest rates are extremely low right now, as you all know, because of the way that what are they calling it, the twist?
Can you give some examples of where the market's at right now as far as the rates?
Well, we have seen things that were at 5% have come down like to 4.25%, 4.5%. Things that were 4.5% are coming down to 4.25% to 4%. GEO, which was right before that, we sold 20-year bonds for 3.25%, 3.5%. In 2 weeks when we go out with GEO, we'll have a very good idea of how low the rates have gone, because they're tied to 10-year treasuries.
Got it.
So as those go down, the long-term debt will come down too.
So in a city of our size, with all of the paper we have out there, that's millions and millions of dollars in our favor when we see the rates do that and we can actually get back out there and refund.
Correct. It's not good for investors, but it's good for us.
I'm not here representing investors.
I know, I'm just,
Okay. Let me say thank you very much, colleagues, who moved this, approved the CAO recommendations on this item. Do we have a date for this in council? Did we get?
Let's set one.
Sooner the better.
Yeah, soon.
Next Tuesday,
Okay.
October 11th.
October 11th. Thank you very much. Last item?
Last item, it's just a small item. It's the CEO's first financial status report and addendum report for fiscal year 2011-12. And we'd move for approval.
You want? Yeah. I was just sitting, Monique sent me an email or text and said, what about consent? And I said,
That's okay.
I said, we would never allow the CAO to work this hard and not forward for hours.
But we're good.
Yeah, we don't mind. Okay. Melissa Cran's Office of the CAO. This is our first financial status report for the fiscal year. In it, we provide a closeout for fiscal year 2010-11, as well as an update on the current year, which includes budgetary adjustments of $129 million recommended for department. So first with the 10-11 closeout, because of the operational plan and alternative plan and other cost-cutting measures, 2010 closed within budget and without an additional transfer from the reserve fund. Additionally, austerity measures allowed departmental savings, higher than the departmental savings, to close the fiscal year with a reserve fund balance that exceeded the 2011-10 adopted budget by $23.5 million. However, revenue was down about $5 million. This represents 0.1% of budget. Property sales, utility users tax, and transit occupancy tax were above the revised budget, while business, parking, and documentary transfer taxes were lower. However, our most significant revenue shortfall was in departmental receipts, which is about $18 million, and that's shown on attachment 1I. And if you wanted to look at attachment 1A, that is where our status was for the 2010-11 receipts. For 2011-12, for expenditures, we began with a balanced budget. Many of the employee bargaining unit agreements that came after the adopted budget required adjustments to department salary accounts, which mayor and council approved. This used savings from the employee contributions towards retiree health benefits, which reduced the city's contribution to the civilian and sworn pensions, as well as savings in the civilian flex program that was negotiated by the Joint Labor Management Benefits Committee, which resulted in the surplus in the Human Resources Benefit Funds. And then additionally, there were budget gaps projected for departments at the end of that report, which were supposed to be offset with department budget savings resulting from delayed salary step increases, reduced sick leave payouts, and reduced overtime cash payouts. So as a result, most of the departments are now projecting to complete the year within budget. We do have 3 departments projecting shortfalls at this time, which total to be as high as $13.3 million. That includes the Animal Services Department, which is about $300,000. We have the Fire Department for $5 to $8 million shortfall, and the Police Department for $5 million. And the majority of the shortfall is from, MOU-driven bonuses and payouts.
Let me ask you one question. On the Fire Department, when you make the comment in the report that it is considering the UB allocation of does that mean that the 6.9's already been considered?
That's assuming that money's transferred in, and this is the remaining deficit.
So there's 5 to 8 million on top
of
that.
The transfer. That is correct. There is a portion of that deficit that they attribute to the implementation of the new deployment plan, and we can discuss that when the Fire Department section comes up. However, we do have recommendations for both the police and fire departments to develop operational plans to address their deficits by the second FSR. Also, we'll expect to have more information on department budgets. We've only had about 2 months' worth of data to make these projections. And we also have the expectation that, further negotiations with engineering and Architects Association and other bargaining units might affect these projections. So, we don't know where we'll actually be standing by the second FSR. We just want to note right now this $13.3 million deficit, that's only within departmental accounts at this time. So we do have surpluses to offset these, but we just don't know if that will be available to use pending the outcome of negotiations. For 2011-12 revenue, we have current receipts to date on attachment 1B. Right now, receipts through August are close to budget. However, we do have caveats about the downside risks to the economy-sensitive revenues, and these include sales, business, and utility tax revenues, which are associated with the latest economic indicators. These indicators include stalled retail sales, and you can see those on attachment 1C, and rising unemployment on attachment 1D. However, our first quarter of current fiscal year shows city sales tax allocation of more than 9%, and that's like on attachments 1E and 1F, but the city's receipts lag, so we do expect that if any downfall in the economy would be reflected in future receipts. Also, another critical component which affected us making revenue last year is currently concerned this year, and this is departmental receipts, which are currently below plan, and you can see both fiscal year 10-11 and 11-12 receipts on 1I. We also have concerns about related cost reimbursements for city departments that may be affected by decreased employment levels and furloughs. With regards to reimbursements, we do also have a recommendation for departments to be more prompt in processing their reimbursements so that the general fund can reflect that revenue. So that's it for revenue.
Let me just ask you a couple of questions before you go on. Is that one of the, see if you can give us a little bit more depth on the, what I labeled the big five that you talk about are concerns, actuarial studies for lacers, proposed elimination of the business tax, recent court decision on Ardon.
Sure. That's our four-year outlook. We updated it in June, which was to reflect the agreement with the coalition. So there was that $196 million figure that had been discussed before. However, we do expect that gap to increase to 200 or 250 million. We can't really determine a final figure right now because we're waiting for the adoption of new actuarial and experience studies by both the civilian and sworn pension systems. To date, pensions has changed their actuarial assumptions, and this includes like the age of retirement and the mortality, and Lacers is studying other factors that might affect their investment rate of return. Also, for a large, we have other factors like bargaining unit agreements and health care costs, and then on the horizon, we also have these large impacts that might be realized if we were to implement the B tax recommendation, which is to reduce the business tax over 4 years. If approved, this 4-year phase-out would reduce revenue by approximately $425 million in business tax receipts. There would be a proposed offset by property sales and utility taxes. We do have a report pending from this office, the CLA, and finance. Also, we do have a class action liability. The Arden versus Los Angeles ruling allows a class action lawsuit to proceed for a refund of the local telephone utilities taxes, and that might be as high as $750 million.
And then the CRA?
Right. So we'll skip the reserve fund then. So we have other issues of concern which are highlighted on page 6 of the report. These include our sworn retiree health. If you recall, the city froze the health subsidy for future retirees. The pension system obtained an outside legal opinion, which then claimed that the action was in violation of employee vested rights. There has been no legal challenge filed, however, and the board is going to consider this opinion on October 6th, and we are, of course, requesting that the board reject this opinion and immediately administer the approved ordinance. We have the change to the GASB, that's the Governmental Accounting Standards Board rule changes for financial reporting requirements that would apply to the pension systems, that would provide a standard method for calculating and assigning pension assets and liabilities. And this would show up in our CAFR, the Comprehensive Annual Financial Report, and that would probably have the greatest impact on the LACERS methodology. There is no requirement that they change, but, by calculating this twice, that adds to administrative costs for the controller, contracted actuary, and the auditor. And if there was a pressure to use the similar methodology, that would have a fiscal impact.
Let me ask you on that point, is there request that you change the way we report it, or is it going to be more expensive in how we have to outlay our general fund to pay for pensions?
It's right now, it's a reporting requirement that differs from the current methodology, so you would have to put it in your CAFR, and you would have to explain any differences to what the pensions board actually reports. So you would have to essentially conduct two analysis, one for the GASB and one for the current methodology.
And then let me ask you another question. Have we made any headway last time we talked about the end-of-year bailouts of department budgets, that we were going to look at some way that we hold them responsible and accountable when they overspend, so we just don't fill up the budget and then start next year? Has the CAO made any headway on that?
No, I don't know that we're working on any policy. However, right now, we are only having 2 departments that report significant deficits, which we do expect them to address within the second FSR.
I'm talking about the end of last fiscal year.
Well, if you look on attachment 2, we did have a lot of end-of-year reversions, so a lot of the departments were able to complete the year within budget with some additional savings that reverted to the reserve fund. And then we are working with the Controller's Office for any outstanding reserve fund loans.
Because that's one of the things I think we've been looking at ways, since I've been on the Budget Committee, to hold departments accountable. And what happens, because the CAO does such a good job at the end of the year, people don't really believe they have to stay in budget because you're going to fix it. And when you fix it, they start July 1st with a new budget, and they don't even think about where you had to find the $2 million or $3 million or whatever to fix their budget. So it doesn't give them any real reason to stay in budget, because every year you fix it. And we're trying to figure out a way that when people spend money that is not authorized, that they basically have to, and we have to loan the money to them to close out the books, that they're still responsible for it on an ongoing basis. And so we'd ask that the CAO continue to look at how we can look at that accountability. Otherwise, what we hear from other departments that stay in budget is that they suffer because they stay in budget, and then they end up losing money from their budget to pay for people who can't stay in budget. And so we're just trying to figure out how can we appropriately deal with, if it's a loan, and they should find a way to pay it back. But if we impose something like we talked about before, if we impose something like ERIP or something that they had no expectation, then we could understand how we would fill those gaps. But if it's just a straight failure to stay within budget, spent more than I had, and CAO fix it at the end, during June, basically closing out the books, those should be held accountable for the following year budget, and that we shouldn't be forgiving those loans later.
Right.
So that's something we'd ask the CAO to look at, because otherwise it just doesn't, it's not fair for 38 departments or 36 while a couple do not, fulfill.
And we do make an attempt when we do present departments that are reporting deficits to call out those deficits that are within the department's control and those that were outside the budget.
Ben Sahel at the CAO, I would agree with that statement. And in fact, I think the reason why we were able to have those reversions at the end of this last fiscal year was because we came back to your committee with the operational plan in December for those departments that were experiencing deficits. And then we also came back with an alternative plan to the P3 once we realized that that revenue was not going to come in. So we had those interim reports that came back to your committee with solutions that departments were tasked with coming up with. And I believe that is the reason why in this report we're recommending that the police department and the fire department come back to your committee with those operational plans to deal with those deficits.
Okay. Now, the operational plans are for this year's budget?
Yes.
Okay. Because I'm still looking back to, I think we're about 15 million or so from last year that we filled the gaps, and they basically just started the new year with a clean slate.
Well, not with the clean slate. If they were short on the revenue, they had to receive a reserve fund loan, in which case it's a loan and...
Okay, that's what I want to make sure that we're dealing with the loan, because somewhere down the line, it's like dealing with block grant money. It's a loan and then becomes a grant, and then all of a sudden, people feel like if you just outweigh the process, they never have to be responsible for it.
Unless the committee forgives that loan, then it remains a loan.
Okay, very good. All right. You're going to start on page, so we can follow page 18 and just
Sure.
go through the department. If there is no issues on the department, do not feel obligated that you must go through it.
All right, so I'm going to say there's very few issues. I'm just going to call out, for example, Animal Services, they have a deficit reporting right now of $305,000. It's attributed to their salaries general account. It reflects current staffing levels and annual liabilities with regards to night uniform and boot bonuses. In the past, the department has been able to absorb these costs, so we will report back the next financial status report where that deficit lies. With building and safety, I'm just going to call out they're going to complete essentially, they only have 3 departments that won't be within budget, so I'm not going to report everybody else. With building and safety, we do have a transfer from the building permit enterprise fund to the personnel department for expenses associated with a vacant, unfunded special investigator position, and that's in compliance with the mayor's direction to reestablish the investigations unit. There's no issue for CAO. The city attorney was within budget, and they paid off their reserve fund loan of $1.8 million. Last year, they repaid that in September.
So we are working with departments.
Hallelujah.
Can we clarify, when you mentioned that there's no issue with the CAO, you're just talking budgetarily?
Budgetarily. Sorry, I was not clear on that point.
Categorically, budgetarily.
Let's see, the next department, disability, I just wanted to call out that it's a small amount, but they will not meet any of their revenue target. It's only $27,000. However, they will not be able to receive the reimbursement from LAWA with regards to sign language services.
Let me just ask you one thing. And I don't know quite where it was in the report, but on CDD,
yes,
we had been told over and over, and particularly during the block grant, that they were not going to basically impact the general fund. And somewhere in the report, we show that last year they ended up with about a 2.8 or 9 allocation from the general fund. But they told us during the block grant discussion that they had resolved all their issues and there'd be no general fund impact.
Now, I can't speak to that. Is that okay if I get you more information at the conclusion of this?
By the time it gets to council, but I just wanted,
Yes, okay.
'cause I think it was one of those departments that was showing a deficit at the end of the year.
Okay.
But we were told that there'd be no general fund impact. Okay, you're back on course.
Let's see. So the next department that we called out was fire. It's on page 24. As we mentioned before, they will have a $5 to $8 million deficit by year end. Part of that is attributed to their sworn staffing overtime account, which is a result of the implementation of the new deployment plan, and it does assume the transfer from the unappropriated balance for the restoration of neighborhood fire services. Also within this discussion, we have a recommendation to approve the use of $6.8 million in MICLA funds for the purchase of 34 ambulances. And we have the instruction to the departments to prepare an operational plan.
And then let me ask you, on MICLA, I think your department owes us a report on MICLA to evaluate whether we should continue spending it in the fashion that we are. And I won't look to my right because Ray knows that report is.
Yes, that is something we're looking at, yes. It's one of those Indian summer studies where we're looking at the use of MICLA for vehicles, that's correct. So.
Was that Summers 27?
It's coming up.
Let me ask you, there's no comments on finance, but we need to find out where those 4 RFPs that are revenue generating, because they were basically lapsed.
Are you speaking about the collections RFPs?
Yeah, not collections. They're the 4 RFPs that go out and search for revenue that we normally wouldn't get, such as documentary transfer, sales tax. all of those have lapsed, and we have not seen them brought back to council.
All right, for the General Services Department, we want to call attention to the fact that parking lot sweeping services was a function of GSD, which was transferred to the Bureau of Street Services in 06-07. That funding was eliminated in the 10-11 budget, and to date, the Bureau has absorbed that cost and continued to provide the service. However, Street Services has notified GSD that they will be discontinuing the service, and the Bureau is working with GSD and its office to evaluate possible solutions, which includes the functional transfer back to GSD and any cost estimate that would go with that.
Because one thing I was trying to figure out, if we've cut it out of the department, what was it, Street Services? Or-
It was moved to Street Services, and then it was cut from, the funding was cut from
But if
Street
we cut it and it goes back to General Services, how are we going to fund it, or do they have the ability to absorb it?
That's what the report is, we don't have that information yet, we will have to report back on that. For housing, there's no issues included in this report, but there is an addendum on that.
Okay. And addendum deals with a couple of transfers of funds?
That is correct.
Okay. So that's the one, colleagues, is dated September the 30th.
For ITA, we have another recommendation to approve $3.7 million in MICLA funds for various technology projects. These include the 800 megahertz radio upgrade, the fire department antenna replacement, the Marvin Brade data center power upgrade, the data backup system upgrade, and network infrastructure.
Okay. One thing in another part of the report where you talk about the ITA going out for RFP to get a technology consultant.
Yes, that is in section 4, I believe. It's our update on the 3-year plan.
I would just ask, before we do that, if we can ask them to pull, I think we've done no less than 8 or 9 studies over the last 5 to 7 years. If we can pull those studies and see if we've implemented the items that are in those studies.
So before the RFP?
Before the RFP, because it might help us write a better RFP if we've either done it or not done those things. So I would ask that that be done in preparation of an RFP.
Okay. Under police, we also have that $5 million deficit that we reported, which is for their sworn salary account, which has been offset by savings already in the civilian and overtime accounts. That's also an MOU-related payout, and once again, we have a recommendation to develop a plan to deal with that.
Okay. And then let me ask you just a side issue, please. What was the final thing we did in this year for the in-car video?
I'm sorry, what was your question particularly with?
In-car video, did we fund another bureau or another aspect of it, or another
That I
phase?
can't say.
Yes, we did. We did fund the next
Next phase?
for the phase, yes.
Okay, all right.
Okay, for sanitation, it's no issue. They did transfer some money within their account to fund a part of the Lifeline subsidy. They do project, however, that they will be within budget for this year for that subsidy. Street services, they wanted to call out the potential loss of revenue from the elimination of the photo red light citation program. Once again, we haven't quantified that. That revenue goes to the Traffic Safety Fund, and it funds both the Bureau and the Department of Transportation. So depending on the impact, it could affect appropriations.
When they show these figures of 4.8 million and 8.3, how much of that would be red light?
That's what we don't know. They need to quantify that. So we need to see how big that impact is. If it's small, it wouldn't impact those appropriations at all.
And then if whatever the cutbacks are, if we could put them into the districts that people voted against it.
Second.
All right, so that concludes any issues in the departmental section.
Let me just, on transportation, do we have any information on their 5-year plan? I think we've implemented phase year 1.
Are you
that one
referring
of
to the
our-
parking? Referring to the parking?
Yeah, SPRF.
That was
At
one
this
of
point,
our,
we don't, yeah, we don't have any update on that yet.
Okay, all right. If we can get something on
That's
that.
this one?
We don't want to move too fast now.
No, I know you're just trying to spend it before we find it. Okay, next. So you've gone through the department?
Yeah, those are our primary issues within the departments. Within the non-departmental accounts, we do call out, once again, the Arden versus City of Los Angeles in the liability claims account section.
Yes.
So the city attorney is working with council and mayor on potential measures to mitigate this. That's it for the non-departmental section. Did you want to go over all the individual sections following?
Unless there's some questions from, I think you've given us some information that the merger of Treasury and Finance is done.
That's correct. On Section 4 gives you an update on that. The implementing ordinance went into effect on August 17th. They've filled a assistant director of finance position, and for the treasurer's services are performed out of the former treasurer's office.
Okay. Maybe you could just give us a brief thing on the three-year plan and the alternate service delivery.
Okay, so that's on page 45. So we have the Animal Services Northeast Animal Care Center finalizing contract with Best Friends. We have the Southwest Los Angeles Animal Care Center. They'll be issuing a request for proposal before the end of 2011. The Children's Museum of Los Angeles, the city is seeking a partnership with the nonprofit operator. Prop K Oversight and the RAP Board are reviewing the exhibit program, operational plans, and financing options, which will be submitted to council before approval. We have the ITA, Alternative Service Delivery, which we discussed. The Convention Center, council instructed this office to release an RFP. We will report back prior to its release. The goal for the RFP is to allow more flexibility and efficiency within the operations of the convention center and maximize the city's position with the convention center as a destination.
I thought it was made clear we were going to wait on the convention center until we figured out that the stadium deal was done. Put out an RFP now because they would be...
No, any RFP would wait until we went back to council.
We'd wait until all
Correct.
that was resolved
Correct.
before putting out an RFP.
Yes, we're not in before we release the RFP, we would come back to council. The LA Zoo, the city council authorized the release of the RFP to experienced organizations to operate and manage the zoo and botanical gardens. We released this on the 29th, and proposals are due the November 7th.
Then the last couple of things I'd ask you to cover is the issue of the fee increases that have not been implemented. And
Okay.
if we have a solution to those.
The fee increases.
So page 47.
Page 47, we have several departments that had fee increases. That's animal services, fire, police, planning, and street lighting. The only fee increases that have not been approved is the industrial building inspection fee. This is in the early stages of process, but we do not expect the $1 million in revenue to be received. However, the fire department reports that they have other revenue that will offset this shortfall. We also have the banner permit fees and fines. This is not proceeding. My understanding is there is a motion that kind of contradicts this, and so that is pending.
Okay. If we could ask the CAO's office to follow up on those 4 or 5 that are not implemented and to get us a status and the potential implementation time. We've already discussed, Nicola, the last thing I have is if you just give us a thumbnail on the state budget.
Okay, so we touched on a lot of the state budget earlier when I first started. The state budget closes about $26 billion deficit primarily through spending reductions. This includes $15 billion cuts to social welfare and higher education. There was no compromise regarding extending taxes. The majority of the deficit will be offset the tax increase will be offset by higher than expected revenue, which is $4 billion for 11-12. But this revenue may not be realized. So as a result, there are trigger reductions, which might impact the city. This is called out. It's I believe the Tier 1 and Tier 2 might impact city libraries. So specific for the budget and the triggers, this includes the CRA redevelopment budget, and that's on page 51. The state legislature enacted 2 redevelopment trailer bills that eliminated the agencies unless the city is elected to participate in the voluntary alternative redevelopment program. We did choose to do that, which means that the city has to pay $96 million starting in 11-12, and then 25 to 28 million thereafter. The city is appealing this amount. Additionally, a lawsuit has been filed to challenge the legislation itself, which we do hope that there will be finding before that payment is due January 15th. With the motor vehicle license fees, that has been cut. We have received, so the cut itself was about $14 million. We did receive $10 million from the state this fiscal year from prior year receipts to offset that, so that shortfall is about $4 million. We do receive COPS funding, state COPS funding in replacement to that. However, that money cannot supplant general other funds, so that COPS money has to be within the police department budget. That police department budget cannot change. It cannot be used for other purposes. We had previously reported that the enterprise zones might be affected, but that has since changed with the latest budget reiteration. The public library has had about $1.4 million. It did receive the $1.4 million. However, their next budget money that they received this fiscal year for next fiscal year is what is in jeopardy. And then we also have trigger reductions, which would impact the Library Services and Technology Act grant, which is about $300,000, and the Literacy Program grant for $200,000.
So, I'm sorry, under the status of fee increases on number 7, page 47, it says here, the Administrative Citation Enforcement Program was approved by Council on September 16th with full implementation expected no later than April 1st, 2012. I don't know if you have another update on that or not.
You mean since today?
Let's just say the ordinance had not been adopted.
Very good. October 3rd, the operational date is October 3rd.
No, I just want to go over the last thing. You want to do this one?
Go ahead.
Okay. All right, we're going to move to the last one. Give us a quick comment on the winter shelter program that you see as part of that program.
Okay.
That's your attachment.
Yeah, I'm looking for a housing analyst.
And I'd like to have Steve come up just in case we have a question for him. Hi.
Good evening, Anne Marie Sauer with the CAO. Basically, in the addendum, what's happening is there's $461,000 in unexpended prior year appropriations from the Affordable Housing Trust Fund that is being reprogrammed to cover some non-CDBG eligible expenditures. And as part of that, that is sort of making money available from this prior year 36 CDBG funds. So the item that's in here is $90,000 for the shelter in West Los Angeles. As we've indicated, it's a policy decision, obviously, but it would allow the shelter to open on or around October 15th.
Right, and colleagues, I put $20,000 from the PATH group that is doing Vehicles to Home program into this, and this is a critical program right now. I have a substantial amount of issues on Venice Beach and also in Westchester Park, and by opening up the shelter, we have to go before the LASA board tomorrow. This additional $90,000 plus the 20 I put in will allow us to open it in mid-October. It starts with 50 beds, and as our police work both the park and the ocean front, we want to be able to give people an option if they want a good night's sleep with a bed and fresh sheets and a meal. No questions asked. We would rather do that than arrest them and bring them and book them and all that. Those who want help, we want to help. So this will help us go forward. I really want to thank the mayor and his leadership for coming up with the $90,000, complimenting my partnership with him of the 20. And I can announce that tomorrow, hopefully get the vote from that LASA commission, and we will open up the Armory in West LA near the Brentwood area there, and we can service it by the middle of the month. But it is an emergency situation. We do have folks from all over the country at Venice Beach. The ones I'm most concerned about are the young ones that maybe would like some help from dysfunctional situations. But I want to give everybody the option of a good night's sleep and a good meal. And this will help me do that by reprogramming the money. So I'd ask for your support on that.
Colleagues, the questions have been asked. We will approve CAO recommendations on the first FSR and the addendum report. Do we have a date in council? Or is there?
I think we're looking at next week. We don't have a date, so it'd be scheduled sometime next week.
We would like this, if possible, on Wednesday if we could, because I need the funds freed up.
You mean for this Wednesday or next Wednesday?
The sooner the Wednesday, the better. We were hoping this Wednesday. Can you do it this Wednesday?
I don't think we have a placeholder and for this week, so as soon as we do, it'd be probably next Tuesday.
Tuesday next week?
Okay, great.
Okay, thank you. So we'll move that item with that placeholder request.
Thank you.
Thank you. Adjourn.
Bye-bye.